All right, welcome. Welcome back. I am Professor Guerra Pujol, and welcome to the Legal and Ethical Environment of Business. This is our lab number 2. And first of all, I want to sincerely apologize. We cannot meet in person today, as I was downtown attending Adrian Brochure from the DeVos Sports Department presenting on the big business of college. And then I went to a Buddy Dyer's State of the City address. And with the forecast, I thought we would just go by Zoom. I see everybody checking in the chat. That's great. I'll also open up a survey in about 10 minutes, and then the survey will count, since we're meeting virtually, the survey will count as your class activity. And that way you'll get full credit. So here's what we're going to do. Let me show, let's just open up the homepage and jump right in. Let me have it, I think I have it up. So let me do a screen share. All right, and then let me just go to our course homepage here. Hold on here while I move this. All right, great. So I want to just show you these some screenshots of some headlines regarding ChatGPT and other what are called Gen AI or generative artificial intelligence models or platforms. As you know, right by now, we're devoting this course to this new technology because I think, it's probably going to be very important, like it or not. So we'll jump in and do, legal and ethical environment of business with a focus on these new artificial intelligence models. All right, so you see some of the headlines here, and you see there's something here, the FTC, Federal Trade Commission, conducting an investigation over a data leak, and also the inaccuracy of the model. You see here on the BBC News an essay about, or report about private conversations being leaked. You see another headline, I think it was from Wired or The Verge, one of those websites I like to frequent, about walking the digital privacy tightrope. You know what I mean? In order to enjoy, many of you probably use Instagram or TikTok or other social media platforms. Maybe you're starting to use ChatGPT and other platforms like that. It's all quote unquote free, right? But you're really exchanging your data, right? And perhaps even your privacy rights when you use these websites. And you see this other article here from the Washington Post about cybersecurity, which is a huge topic. In fact, our institution, the University of Central Florida, our College of Business, along with the computer science department, offers a program, a certificate, in cybersecurity. These AI poses a new challenge. So what I want to pose to the class before we begin today's topic is, you may recall what we did in our first lab, our first module, right? We talked about, should we regulate AI or should we allow the invisible hand to work its magic? And by the way, based on our in-class groups that we did when we met in person last time, and based on the individual survey, the consensus was that we should regulate artificial intelligence, But here's the deal, right? There is no artificial intelligence regulation in the United States or at the international, treaty or convention level. The European Union has enacted some pieces of regulation and legislation. In the U.S., there is no regulation, at the federal level. And of course, there's no international treaty yet, or no, United Nations, framework. So here's the question I have for the class. What do you do? How do you deal with these problems like privacy rights and other, cybersecurity, et cetera, when there's, in the absence of regulation, when there are no federal laws or international treaties that deal with this matter? It seems to be quite a conundrum, right? Well, that's why the topic of this module of this lab is the common law. The common law is, I will submit to you, the greatest or one of the greatest intellectual achievements of the Anglo-American world. What is the common law? Well, let me show you something. I normally, this is what I lecture on. This is what I've been doing for years. I'm a student of the common law to this day. But right before class, I went to ChatGPT and I asked ChatGPT, tell me, what is the common law? And just to compare notes. And I thought it gave me such a good answer. And I don't mean to do a cop out, like not do my job, but I want to share with you ChatGPT's answer because it did a really good job. But then I'll say a few things that are not in this answer. You see here that common law refers to basically judge-made law, not to legislation, not to international treaty, but to judges deciding cases. And what happens is when a judge decides a case in a common law system, that case becomes a binding precedent for the lower courts in the court's jurisdiction. And so here you have, that is the essence of the common law. And by the way, one of the awesome things about the common law, in my opinion, is that it's not just an Anglo-American phenomenon. Everywhere that the British Empire used to impose its will, even though, beginning with the USA, when it was the American Revolution, India's independence in the 1940s, the partition with Pakistan, New Zealand, Australia, and Canada, are, for all practical purposes, right, independent sovereign nations. All those countries are common law countries, because even though the British were expelled in terms of ruling those countries politically, those countries continue to maintain in their legal system the common law tradition. And by the way, it's not just New Zealand, Australia, Canada, India, Pakistan, Zimbabwe, Kenya, anywhere where the British ruled. Also in the Caribbean, Jamaica, Barbados, Bermuda, you have a common law heritage as well. But look what the ChatGPT told me. It begins, I thought, wow, precedent, stare decisis. And I included in the module, by the way, everything I talk about in the class, you'll find it in the module for lab number 2, the module on AI and the common law. So precedent, when a judge, especially a judge of an appellate court or a Supreme Court, when those courts make a decision, it becomes binding precedent until it's overturned. Case-by-case development. Common law is incremental, right? Judges just can't decide a case decide the legality of an issue or a topic in the absence of an actual legal dispute. So there's got to be a case, and then judges have something to work with. Judges do not decide hypotheticals. They decide real cases with real people. This is what separates the common law from philosophy, right? Philosophers and law professors, I should say, right? We can have, we can engage in hypotheticals all we want. Judges have to decide actual cases, actual problems. Flexibility, because the common law is case by case, because the common law, when judges are deciding the case, the facts of the case are really, really important. Judges can try to tailor their result, within the binding precedent that they have to apply to the facts of the case. So there's this flexibility. And then because the courts are deciding incrementally, one case at a time, they can build on the previous decisions, maybe distinguish some of the older cases, maybe overturn some of the older cases, that kind of thing. You see your legal principles and precedents. Here now, ChatGPT is kind of being redundant here. We already talked about binding precedent. And then this idea of equity. Technically, this is totally wrong. Here where, I finally get a hallucination. I'm actually excited about this. Equity is totally different from the common law. And I won't get into all the technical reasons. Equity, I'll just tell you historically, back when the common law was developing, the so-called King's Bench or Queen's Bench, depending on who the monarch was, there was a separate court called the Chancery Court, which was a court of equity. And what the court of equity would do is, when the common law wasn't able to provide when the common law wasn't working, or when people were not happy with how the common law was developing, the equity courts could step in. Now, I will tell you today, for all practical purposes, in both the United Kingdom, England, where the common law originated in equity, and the United States and the other countries that I mentioned before that are common law heritage countries, equity and the common law have been combined. And so today, for by and large, in most places, I think there's some places like Delaware and Mississippi where there's still a separate equity court. And we won't get into all that technical detail. But by and large, I thought GPT did, it got I would give this a B plus, maybe even if I'm in a good mood, an A minus. You know what I mean? Maybe a B plus. It was a little bit redundant by mentioning precedent twice. But it's true. The common law, what judges do are developing these legal principles, these legal doctrines. Now, I want to give you a specific example because, and I'll do that by opening up today's survey because I think privacy is one of the most important problems. Not the only problem, not the only potential risk that you have when with social media and Chat GPT and other Gen AI platforms. But certainly privacy is a real big problem. So let's go ahead and and in fact, the common law, to give you an example, has developed a tort called invasion of privacy. So let's go ahead and jump in the module. I've included all the information about invasion of privacy so that you don't need federal regulation if you feel that you've been damaged or harmed or injured by social media platforms or by Chat GPT. The common law is there. It's this background area of law. And the common law, the judges have developed these three, and you'll see it in the module, three broad areas, the way we study it in law school. Torts, or the law of wrongful acts. Contracts, or the law of promises. When is a promise legally enforceable? And finally, property rights, or property law. And so I have, today I'm going to focus mostly on wrongful acts, which is probably the most important area of the common law. But clearly, contracts are super important, and property rights are super important as well. I'll say a few things about those other two areas of law at the end of the lecture. So if you'll just give me a minute to go ahead and I will, let me go ahead and what I'll do is I'll put the survey in the chat. I think that's the best way to go about this. So just give me 1 second to pull up the survey. I thought I had pulled it up, but I apologize that I accidentally closed it. And so I'll go ahead and pull it up now. All right, let me get into the chat here. Let's see here. I don't see the, let me just get my glasses. All right, I think I'm in the, okay. All right, I went ahead and posted the survey in the chat. Awesome. And then go ahead, take your time. It's 4 questions. It's a graded survey, anonymous. You get full credit. There's no, right or wrong answer per se. I just want your feedback. And then I'll show you, the purpose of the survey is to show you how the common law actually operates. When you've been aggrieved and there's no federal law or international treaty, or even state law, you have the common law as a background. So I'll go ahead and do that. I'll put a little background music and mute my camera, give everybody a few minutes just to do the survey. Just take your time, enjoy it. We'll go over the results, and then we'll begin to wrap up today's lab.
Everything is fun right.
All right. If you had any trouble activating the survey, I went ahead and I'll repost it in the chat. Just to make sure everybody's got it. And we'll go ahead with what we have and look at the results. And then we'll use those results. You can see how the common law, how do you impose legal liability, in the absence of regulations, what we have the common law for. That's why I consider the common law really the greatest intellectual achievement of the Anglo-American world. So let's go ahead and jump in here. What I'm going to do is, let me just double check that I can get the survey results. My survey statistics, and then if I have those loading. Okay, good. I do have survey statistics now, so to share with you, so I can go ahead and we can go ahead and just jump in without further ado. Let me see if I can just move this up so you can we can see this better, and let's see if I can make this any larger. Let's see here. I think this was the your micro essay that's now pending. You know what I mean? I posted it as a survey just because it'll be easier, instead of me counting each one of them, and keeping tabs. I just want to see individually what you think. This would have been the group activity, by the way, had we met in person. And I'm sorry this is so small. I just realized here it's a little bit small, but you can see there's really 10. Some of these are kind of redundant, but let's just go and see the results. And here, what I'm trying to ask you, is that this is why the common law is so important, right? Because the common law imposes liability for harm. But here's the important point that I want to mention before we jump in here. You see, there are a number of harms in here. Oh, and by the way, what I did here is I took the liberty of kind of combining it like more logically. ChatGPT, like you saw when I asked ChatGPT what is the common law right before class, I kind of had this, why not, and it did a pretty decent job, a B plus. Here what I did is, it gave me 10. I asked it for 10 harms, and I kind of like categorized them into a smaller number of categories. Aesthetic harms, economic harm. So aesthetic harms is basically, like people are going to be more lonely now, instead of interacting face to face. Like you may prefer the in-person class and not the Zoom, or vice versa. You may prefer the Zoom and not the in-person. That's totally aesthetic. You know what I mean? There are advantages to each, disadvantages to each format. Completely aesthetics, like art. Do you like Picasso or do you like Matisse? You know what I mean? Do you like Van Gogh or do you like Gauguin? You know what I mean? They're all great artists, but it's sort of an aesthetic choice. Then I talked about economic harms, like people losing their jobs. By the way, I just attended a conference on AI that was actually held here at UCF, nationwide conference, people from as far as Alaska and Latvia, one of the Baltic republics. And it was amazing. One of the things I learned is that you're not going to lose your job to AI. According to the keynote speaker, Professor Dobrin from the University of Florida, he said, but you are going to lose your job to somebody who knows AI. And that's why I totally agree with him on that. And that's why I'm using AI as the theme of this course. So nobody is caught off guard when you graduate. You already know AI, you're exposed to it, you're comfortable with it, and then you make your decision how much you want to use it. So economic harms, ethical harms, the problem of algorithmic bias and discrimination and stuff like that, the kind of answers it gives you. And I call here this information and educational harms, the fact that people are going to stop thinking, the fact that you get false information. And finally, I put here privacy harms. Oh, not finally, I put privacy harms. And then I put psychological harms, like addiction. People are going to be like so into it, And look what got the most votes. And nothing commanded an absolute majority. All of these are serious harms that will probably come about because of ChatGPT and other AI. Let's be honest about it. I'm not going to sugarcoat it, but look what got the most votes: privacy harms and security risks. I combine that because privacy, right, is the lack of cybersecurity, and vice versa. Lack of cybersecurity will lead to privacy violations, right? But here's before I move on, this is the larger point I want to make that I want you to understand. Just because there's a harm doesn't mean there's legal liability at common law, unless there's some kind of regulation, like an aesthetic harm, an educational harm, informational harm, with the First Amendment. You can't sue for that, or we'll see. Maybe the courts will step in and the common law goes case by case. Common law evolves over time. Common law, is where the genius of the common law is, it's known. In fact, the great Oliver Wendell Holmes said, the life of the common law is not logic, it is experience, right? Because it's based on actual cases and it develops as new problems and new cases come into the system. But that's the first main point I want you to get out of this module for the common law, that just because there's a harm doesn't mean there's legal liability. But when it comes to privacy, there is a tort called invasion of privacy. Privacy is one of those things that, if your privacy is invaded or harmed, there could potentially be legal liability. So let's take a closer look at this. And by the way, I described the different types of invasion of privacy. There's actually 4 different ways that your privacy can be invaded in the module. Because of the format of this class, we won't, normally I would do, a whole lecture on this, but let's jump in. Let's look at our other survey questions here. And, but as an introduction, now you know that invasion of privacy, right? There's no federal legal regulation, general federal privacy law. There's one, yes, for the Health and Insurance, Portability, Act. There's a one for Federal Educational Privacy Rights Act. There's a number of ones for like specific settings, but there's no general federal privacy law. There is the common law, though, privacy rights, invasion of privacy. Now, my next question is, did I ask this twice? Here I'm asking, so here I'm asking which one you thought was the most serious. And here I'm asking which one you think is most likely to occur, and by the way, the reason why I'm asking you this question here, and I did the same, categorization: aesthetic harms, economic harms, et cetera, privacy harms, et cetera, is because this is why, this is often what's called strategic legal thinking. When you operate a business, small or large, you have to anticipate what your legal liability risk is going to be. And so you have to ask yourself, first question, what's the worst that can happen? You know what I mean? And second question is, what's most likely to happen? Because then you can actually consult with an attorney, you can take steps to avoid the legal risk. You know what I mean? If you get sued, you're prepared ahead of time. Because trust me, if your business is going to be successful, John Morgan is going to be knocking on your door. Dan Newland is going to be knocking on your door. They're going to want a piece of your action. That's just the reality of it. And so, here, I just want to know, okay, most people thought that privacy was the most serious harm. What's the most likely to occur here? And here, notice it's false information is the most likely to occur. Now, this is interesting, We'll see how this plays out, because GPT-4, which I'm not requiring because it's a subscription-based model, I think you got to pay $20 a month for it. It's supposed to be more accurate and better than the free version that I've been using, 3.5. GPT-5 is coming out soon, according to the rumor mill, by December. Google's going to release something called Genesis, which is supposed to be even better than GPT-5. So, but maybe there will still be, problems with accuracy. So we'll see what happens there. All right. The next question is, so this next question is, should there be legal liability for any of the harms that, if any of these materialize? You know what I mean? And, because you often hear, you got to be accountable. You got to be, you know what I mean? You hear this, personal responsibility. How is it that all these companies can do potentially bad things and not suffer any legal consequences? You know what I mean? And so let's see here. Look at what we have here. 75% believe that, yes, you know what I mean? These companies, making all of this money, there needs to be some accountability. This is why I'm telling you the common law is so important, because the common law gives you the tools to hold companies accountable. And let me tell you here is, but how? How can you hold the company liable? Using the common law. So there's two big theories of legal liability, and that's what I want to share with you now with the last two survey questions. So this survey question here is, I introduce you to a theory called negligence. It's a legal doctrine, common law doctrine. And the basic idea is that you or your business is legally liable when somebody gets injured. If, and by the way, I have the elements of negligence here. You owe a duty to that person. And then these other elements. Now, when does the law impose a common law? This is all common law. It's all judge-made, going back to the Middle Ages in England. When do you owe, or when does the business owe a duty to a stranger, to a third party, to a customer, to a neighbor? Well, you owe a duty if there's a harm that's foreseeable and you fail to take reasonable steps to avoid the harm. You know why that's super important? And I've laid it out here in the question. Go and take a screenshot. The harm has to be foreseeable. It's got to be something that, you knew could have happened, and you failed to take reasonable steps to avoid the harm. Now, the reason why this is so significant, this common law doctrine, and it's why I say that I think this is the greatest intellectual achievement in the Anglo-American world, is because ChatGPT itself identified 10 potential harms. By definition, these are foreseeable. You know what I mean? ChatGPT itself is telling me, what it might do bad, or what the bad effects might be or harms might be from too many people using ChatGPT, over relying on it. You know what I mean? So it's like, definitely these are all foreseeable, right? ChatGPT itself is telling me what these are. You know what I mean? Now, if it's not on the list, what if I ask for 20? What if I ask for 50? You know what I mean? At some point, there's some harms that are so remote, you know what I mean? That maybe you could say those aren't foreseeable. But that foreseeability test is super, it's the genius of the common law. Foreseeability is the test of legal liability. If you're a company and you put out a product, or you're an individual and you take an action or fail to take an action, and it's foreseeable that somebody could be injured using your product, or because of your action or failure to act, you could be legally liable. But that's only half of the equation. The other half is, did you take reasonable steps to avoid the harm? And I'll put the formula back here, the legal, with the elements of the tort of negligence. The reason why that's important is because it's not obvious, but I'm going to say it because I want to blow your mind right now. If you do take reasonable steps to avoid the harm and somebody still gets harmed, guess what? You're off the legal hook, right? It's only when you fail to take reasonable steps to avoid, foreseeable harm that you could potentially be legally liable. Now, this is why you always need an attorney, right, to kind of navigate, because the common law is judge-made law, and because in the United States, in the U.S.'s legal environment, we have 50 states plus a number of island possessions or island colonies, for all practical purposes. You know what I mean? The common law in each of these states and islands has developed differently. You know what I mean? There are minor variations, sometimes major variations in how the common law develops. You know what I mean? But this is giving you sort of like, broadly speaking, and it's why it's called the common law. That's more or less the same in England as it is in India, as it is in New Zealand, as it is in Jamaica, as it is in Florida and our sister states. You have to take reasonable steps to avoid a foreseeable harm. If you don't do that, you could potentially be legally liable under the theory of negligence. So here, my question was, should OpenAI, should the court say that they owe a duty to its users? You know what I mean? to basically take reasonable steps to avoid foreseeable harm. Now, this is a legally imposed duty. And so notice 91% of the class, you are already thinking like the common law. You're already thinking like the common law. That is the common law duty. Everybody owes this duty to take reasonable steps to avoid foreseeable harms. You know what I mean? You don't have to take, absolute steps to avoid all potential harms, just reasonable steps to avoid foreseeable harms. Now, one of the things you learn in law school is that, well, what's reasonable, right? What's a reasonable step? What is a foreseeable harm? And let me tell you, right? That's why you need an attorney. That's why we have the courts. That's why we have judges. That's why we have case law defining what is reasonable, defining what is foreseeable. I will just tell you as a general matter, going back to Oliver Wendell Holmes, who wrote a great book called The Common Law. It was Oliver Wendell Holmes, who I quoted earlier, who said the life of the law is not logic, it is experience. Talking about the common law. What the common law has done is develop what's called an objective standard or an objective test. Basically, an average person, you know what I mean? It's an average person. What would an average person consider reasonable? What would an average person consider foreseeable? You know what I mean? You don't have to be super smart. You don't have to be, you know what I mean? Just the average person. So the courts try to apply an objective test so the law is the same for everybody. Now, it's a real deep discussion. How objective is the law? You know what I mean? What is really reasonable? What is really foreseeable? But let me tell you something. This is why we have juries. Ultimately, when the system is working properly, juries get to decide what is reasonable, what is foreseeable. That's that's why we have the jury, because the jury is made up of ordinary people. All right, I think our last survey question, if I'm not mistaken, is I'm introducing. This should have been a bold. Sorry about that. Introducing you to another legal theory of liability, also developed by the common law and by the judges. That is strict liability. And what strict liability says is, I don't care if the harm is foreseeable. I don't care if you took reasonable steps or not to avoid the harm. If you caused the harm, you're legally liable, point blank, period, end of discussion. You know what I mean? And generally, I'm going to tell you right now, the common law only apply. Negligence is the default test for determining when somebody is, legally liable to somebody else. But strict liability does apply in what's called, and I have a graphic here, what's called abnormally dangerous activities. So owning a wild animal, companies that, demolition companies and companies that use explosives, you know what I mean? And also products liability technically is a strict liability area. And in fact, if I'm a lawyer and I'm going to go after OpenAI, if I'm John Morgan and I want to sue them, I'm going to sue them under strict liability, right? Because it's easier for me to prove my case. I don't have to prove that the harm is foreseeable. I don't have to prove that, OpenAI took reasonable steps to avoid the harm. I just go strict liability. My client was harmed, boom, end of story. But it's got to be an abnormally dangerous activity, and personally, or, a product, and you could say, is this something the courts will have to decide? Is a Gen AI, a chatbot, is that a product or a service? You know what I mean? That's a definitional thing. That's why we have the common law to decide this case by case. Let's see what I asked the class here, which doctrine should apply to AI companies? Everybody agrees AI should be liable, if somebody gets harmed. Everybody agrees that 91%. That's like North Korea numbers. Kim Il-jong, he wins by 91%. Saddam Hussein, when he was in power, he would win by 90+%. Everybody agrees, companies should be liable if somebody's harmed. But what theory of liability do you think should apply? And here, notice it's really, really much closer, right? The bottom line here is what I want you to know, is why you always need a lawyer. Because if the courts, and we don't know, this is all brand new. This is all brand new. You know what I mean? There are some lawsuits now in the system against OpenAI. We'll take a look at some of those lawsuits in the next module. Just last Tuesday, John Grisham and George Martin, the author of Game of Thrones, and John Grisham, the author of these lawyer novels, Jodi Picoult, best-selling romance novelist, they all sued OpenAI, for copyright infringement. We'll take a look at that next class. And then in 2 classes from now, we'll look at some of the other lawsuits OpenAI is facing. You know what I mean? But what theory of liability should apply? If you're a plaintiff, if you're the victim, if you're the one that's suing, you would prefer a strict liability, because it's so much easier to prove your case. You don't have to show foreseeability. You don't have to show reasonable steps. You just have to show that you were injured. If you're the defendant, if you're the company being sued, right, you'd prefer not to be sued at all, right? But if you are going to be sued, you'd prefer to fight using a negligence doctrine. So you could show that the harm was foreseeable or not. Maybe it's unforeseeable harm. You know what I mean? And even if the harm is foreseeable, right, as we saw with ChatGPT giving us the 10 harms, you know what I mean? Potential harms. Even if it is foreseeable, did ChatGPT take reasonable steps to minimize the harm? You know what I mean? Maybe they could argue they did. I will tell you, it's all proprietary, so I don't know the specifics. But OpenAI says that they've invested a lot of money to kind of prevent ChatGPT from being discriminatory, from engaging in bias, from doing terrible things. Previous chatbots, basically they would do terrible things. You know what I mean? But the ChatGPT apparently has these good guardrails. By the way, those guardrails have been there are ways of circumnavigating them, and getting around them. So, I'm telling you, this is going to be decided by the courts. But that's, to me, the genius of the common law. Now that we're done with this, let me do a quick time check, and let me just go into the module, because I do want to say a couple of things that are in there, and then give you a preview for the next class. Because now you have, by the way, a great, introduction to the theories of legal liability. You know what I mean? But in addition to negligence and strict liability, there is also something I want to share with you called invasion of privacy. And there's you see, I've given you some links that give you some further information about how your privacy can be invaded. One of the things, though, about invasion of privacy, and I just want to throw this out there, is the courts have developed a special doctrine called the reasonable expectation of privacy test. In order to sue for invasion of privacy, right, you have to have a reasonable expectation of privacy. And again, the courts will use that objective test. What would, for an average person, would you expect privacy? So if you're in a public place and somebody takes your picture, that could be very creepy. That could be very impolite. But you really have no expectation of privacy. You could slap the person or, shout at them, why are you taking my picture? But you can't sue them, or you could sue them, your case will get dismissed. Now you're in a private place, you're in the bathroom, you're in a fitting room at the department store. You have a reasonable expectation of privacy in those areas, right? You would think, right? But I want to show you something here, and I've included OpenAI's terms of use. They have a disclaimer clause, right? It's why you always have to consult an attorney. And let me see if I can make this a little bit larger. If not, I actually pulled up OpenAI's terms of use here. I'll scroll down, and you'll see that I believe it's over here, number 7. You see there's a disclaimer, and oops, sorry, what did I do? Oops, I don't mean to print this. I just meant to make this bigger. Let me see if I can close this. Apologize for that, it's my bad. Let me just make this a little bit bigger. So this is why you go to law school, right? This is why you need a lawyer, because is the disclaimer, is it enforceable, right? That's a whole other topic. Generally speaking, disclaimers are enforceable, but the common law has developed differently in different states. Generally, the disclaimer has to specifically identify the harm that it's, disclaiming, if you will. Same thing with limitations of liability. Generally, also courts say that, it's got to be reasonable. Again, we go back to that. You know what I mean? So you can see we could go on and on and on with this discussion. You know what I mean? I will tell you, right, if you're running a business, right, this is why your terms of use, is why your contract and user agreements are so important, because you'd like to have a watertight disclaimer in there so that if you do get sued by John Morgan or by Dan Newlin or whoever, right, you can show this to the judge and get the case dismissed. But I'll tell you, it's not that easy, because whether a disclaimer is enforceable or not does depend on the common laws that's developed in each of the states, right? Now, here, if we take a look at this agreement, dispute resolution, You're going to see there's an arbitration clause. We'll talk more about this when we get to module 2 weeks from today, when we talk about civil and criminal cases and how companies use arbitration clauses to avoid going to a jury. So ultimately, whether this disclaimer is legally enforceable is going to be decided by an arbitration panel, not by a judge or by a jury. And that, I would be worried, if I'm a user here, if I'm a potential victim, but we'll say more about that because, we have 5 labs and I don't want to do all at once, that's why I'm just introducing you to this to show you how the common law has developed that, yes, common law imposes legal liability either under a negligence theory, 90% of the time. And in the other 10% of the cases, where it's an abnormally dangerous activity or a product, we're going to be talking about strict liability. But that's, but if there's a contract, courts will generally enforce disclaimers if the disclaimer is specific enough. Now, this disclaimer, it's all caps. I personally don't know how specific it is. I'm not a judge, but that's why the facts of the case are so important. Now, the last thing I want to show you is, remember we've been talking about you want to sue for invasion of privacy. You want to sue if you're harmed under a negligence or strict liability theory, preferably. But there is an interesting question that is unresolved, and I have this in the module. Let me just go back to the module so I can show you. It's the next to last part of the module. And that is, who owns your data, right? Technically, if you don't own your data, you really have no lawsuit. You know what I mean? Your case is going to get dismissed. You know what I mean? So it's going to be really, really, and I will tell you, this is a question that has yet to be sorted out. The courts are just beginning to grapple with this question: who owns your data? There's a lot of calls for federal regulation here. For a federal standard. In terms of data ownership. There's calls for international treaty, but we still don't have that. We still have that lagoon. So the common law judges will have to decide who owns the data, who owns the data generated by ChatGPT, the outputs. Do you own it? When I put in to show you my what I did right before class, do I own that output because I'm the one that put what is the common law, or does ChatGPT own the output? That is an open question. And finally, the last thing I want to show you in the module is if you saw, this is a bonus, totally optional. If you saw, I'm gonna put a bonus video in here. If you saw the Netflix documentary Pepsi, Where's My Jet? I thought, by the way, it was one of the best legal or non-legal documentaries. Since Tiger King. I thought this was really, really good. It's only 4 episodes. Super, super entertaining. So I have some information in here. I blogged about it. If you want to read more about it, totally optional if you want to see how the common law develops in practice. You know what I mean? So I just wanted to throw that out there. All right. So I'm going to go ahead and stop the screen share. Any questions, comments, or concerns before we close? I think we're done. I do want to make one point because I had a student had COVID. You may not have been able to miss the, you missed the class. And I want to assure you, I'm really strict about no makeups and no, deadline extensions, only not because I'm a jerk, but because of the format of this class. I'm supposed to require attendance, you know what I mean? Whether it be by Zoom or in person. But what I am going to do, and I forgot to mention this, so I apologize, for sounding like a jerk. If you got a nasty email from me or a very curt email, I want to let you know, as long as you go to 5 of the 6, including the orientation class, you will get full credit for your attendance and participation grade. You know what I mean? So you can miss a class and there's no problem, and I'll go ahead and update the syllabus to reflect that. Normally I say that at the first day of class, but one of my TAs, I may have omitted to say that, you know what I mean? Because you are allowed to miss one of the classes without consequences. I don't, so I wanted to throw that out there and put that on the record, have this recorded, and I'll go ahead and update all the course information accordingly. But you should try to go to all the labs. I'm going to try to make it as entertaining and exciting as possible. And I want to thank you for your time and attention. And wish you a great day. God bless and charge on.
Thank you for your time. Have a good day.
Thank you. Now, I just stopped the recording. If anybody does have any questions, comments, or concerns, let me know. You see, this class is super easy. I do a micro essay every Monday. This week, I think it was on Tuesday or Monday night, because I was in a conference, and but it'll be a micro essay each week, and then every other week we'll have a class with an activity. Either a survey or a class activity. We will be going back to in person. Only because of today there was a weather issue, and I was downtown for most of the day, and I live close to downtown in College Park, so I just just so I don't come late to my class. But thank you. But anybody has a comment, question, or concern, let me
I
know.
do.
Here for a few more minutes.
Hello, Professor. Hi.
Yes. Hi. Hello.
Hi. I have a question, please.
Yes.
So, for example, if I work with a company and the company